All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Vasily, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor, or Madam Prosecutor.
Good morning, Your Honour, and to all those joining. For the Specialist Prosecutor's Office this morning are Jack Smith, Specialist Prosecutor, Alan Teager, Senior Prosecutor, David Harbach, Prosecutor, Marlene Yaha, Legal and Disclosure Officer, and I am Claire Lawson, Head of the Legal Office. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. May counsel introduce themselves and their team, starting with Mr. Hooper, please.
Yes, good morning, Your Honour. David Hooper, assisted this morning by Sophie Menegon and Astrid Palaska. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Good morning, Your Honour, and to all those in court. This is Ben Emerson representing Kadri Vasily.
Thank you, Mr. Emerson. Mr. Young, please. Mr. Young, your microphone is off. If you could repeat, please. Thank you.
Forgive me, can you hear me now?
I can hear you. Yes, please continue.
Yes, thank you. This is David Young representing Recep Selimi along with Mr. Jeffrey Roberts. Thank you.
Thank you, Mr. Young. And now, Ms. Alagendra.
Good morning, Your Honor. Venkateshwari Alagendra, representing Mr. Jakub Krasniqi, appearing together with Mr. Aidan Ellis and Mr. Mentor Bichiri.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thaci, Mr. Vasily, Mr. Selimi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the registry, please. Mr. Roche.
Good morning, Your Honour. It's Ralph Roach, Head of Judicial Services Division in the Registry.
Thank you, Mr. Roche. And for the record, I am Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, I remind the parties that should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. And if the connection with any of the remote participants fail, we will do our best to reconnect immediately. If the issue cannot be resolved rapidly, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Let me now move to the recent procedural history of the case. On 3 and 9 February 2021, I scheduled this third status conference. I asked the parties to provide written submissions if they so wished on the following topics: disclosure, translation of the Rule 86.3b outline, the Rule 109c charts, the status of the SPO's investigations, the status of the defense investigations, the points of agreement on matters of law and fact, the date of the next status conference, and any other matters they wish to raise. On Monday, 8 February, the SPO and the registry submitted their respective observations, and 3 defense teams submitted their observation on Wednesday, 10 February. I thank the parties and participants for their written submissions. The purpose of our hearing today is to review the status of the case and to discuss the topics I just listed. I will invite the parties to present their views in a concise fashion about each item. I remind the parties to give prior notice should any submission require the disclosure of confidential information. Now I invite the parties to follow the agenda set out for this status conference. And I will first start with the issue of disclosure. I would like to hear from the prosecution on the progress made in the disclosure of evidentiary material, in particular with respect to Rule 1021A material, whether disclosure obligations with respect to this material have been fulfilled, as you anticipated in your written submissions. With respect to the Rule 1021B material, how much of such material remains to be disclosed, and whether the SPO envisages filing protective measure requests. I also wish the SPO to inform the court whether there remain exculpatory evidence in the SPO's custody, control, or actual knowledge, and whether this material requires a judicial ruling on protective measures, and whether it is facing or foresees any difficulties related to the disclosure process, in particular with respect to Rule 107 material. And finally, I invite the SPO to respond to the points raised by Mr. Hooper in its submission about the identification of witnesses and the identification of material related to each witnesses. Madam Prosecutor, you have the floor.
Thank you, Your Honour. With respect to Rule 1021A material, I can confirm that the final items were disclosed in Disclosure Package 21 on the 12th of February, and that Rule 1021A disclosure is therefore complete. Since the last status conference, the SPO has also disclosed 2 batches of Rule 1021B materials. Those are packages 16 and 22. In addition, as the Chamber is aware, on the 5th of February, we filed a request for protective measures in respect of certain further Rule 1021B items. As indicated in our written filing, Rule 1021B materials are being worked through in a systematic way. There is still some way to go, and there will be further such disclosures and further protective measures requests in the coming weeks and months in line with the framework decision. The SPO is also continuing to fulfill its disclosure obligations under Rule 103 with respect to potentially exculpatory items. Most recently, in Disclosure Package 20, released on the 11th of February. We're continuing to review and prepare disclosure of further items pursuant to Rule 103. It is foreseen that certain of those materials may require protective measures. We would expect that to be the case, although at this point no specific request is imminent. With respect to Rule 107 material, discussion with a number of information providers is ongoing, and that continues to be an area that we're actively working on. As indicated in our filing in respect of one of those organizations, discussions are nearing completion, and we anticipate that a Rule 107 application will be made. And as Your Honour invited, I will also take this opportunity to address the points raised in the Thaci defence filing. In respect of witness identification, allocation of a number to persons is something that happens as part of the SPO's investigative process. it is not determinative of whether or not the person will be relied upon at trial. However, all of the materials disclosed under Rule 102.1a are materials which the SPO relied upon for the purposes of confirmation of the indictment. And as previously indicated, it is anticipated that the vast majority of those same witnesses would again be relied upon for trial. With respect to the request to be provided with a witness list, next week, I believe, was the date proposed, I would simply note that relevant decisions are obviously still in process. The witnesses and evidence upon which the SPO intends to rely at trial will continue to be notified in due course in accordance with the disclosure timeline set out in the framework decision. On the specific query relating to the materials of 3 witnesses, the SPO has responded inter partes to that query. And in order to assist all defense teams, last week we redisclosed 9 Rule 102.1a items with the relevant pseudonym mentioned in the description in order to facilitate linkage and identification. The Thaci defense further notes that certain exhibits shown to witnesses during the course of their interviews has not been disclosed. That is correct. What has been disclosed to date is indictment supporting materials and the initial batches of Rule 102.1b materials. Other items, including items that may have been shown to a witness during the course of various interviews, will be disclosed and linked in due course in accordance with the timeline in the framework decision. It is, though, noted that the linking of certain items may implicate current or future protective measures decisions, in that associating certain items to a particular witness could be identifying, and therefore linking of items is a process that may have to be completed in a graduated fashion. Finally, with respect to the submissions on record type and originator fields, these are submissions that I responded to in some detail at the previous status conference. And without having acknowledged that prior explanation, the exact same metadata examples have now been repeated in this filing. I did also indicate at the hearing in December that the SPO is available to address any queries where originator metadata appears unclear for particular items, and no such queries have been raised with us in the interim. So I will simply repeat that the originator metadata disclosed indicates precisely the person or entity from which the SITF or SPO obtained the item. There is no missing chain or hidden intermediary, and we remain available to address any particular queries. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense, starting with Mr. Hooper. Mr. Hooper, you have the floor.
Thank you, Your Honour. May I say at the outset, I'm going to ask Sophie Menegon to deal with these issues. And when I say issues, on the matters that you've raised in your order, there's a cluster of connected issues, whether that's running from your item 1 through perhaps through translation, and definitely as far as Rule 3, Rule 109C chart and the subdivisions relating to that. In terms of disclosure, there have been some specific difficulties that have mainly been addressed by the SPO when these difficulties have been pointed out. But there remain what I'd call a general problem, and that is this, that the system by which the SPO disclosed material has not been done in a particularly helpful manner. I'd go so far as to say of the disclosure systems that we've been subject to at other similar courts and tribunals, this system is the least helpful. And that's a problem because, of course, the manner in which disclosure is made and the assistance that one gets from the disclosing party, particularly when there's a great amount of material as there is here, that assistance should be apparent. That is, it should be, if you like, a bit of a route map through the material that they're disclosing, and that assists the defense to access and to mine that material, to understand the case, and ultimately to, of course, deal with it and to decide its priorities in terms of investigations. In this case, there's 124 witnesses, I think, that have been disclosed. Most of those, of course, as you know, are under pseudonym. There's no summary provided. There's no 5 lines as to what each particular witness might go to. Each witness, no witness is actually disclosed with an accompanying bundle of exhibits. I would have thought that was elementary, that if there's a witness, there should be a bundle of exhibits connected to that witness, rather than have us have to link the witness with particular documents. There's a lack of detail in respect of the material that's in respect of the chart, a lack of detail that the SPO want to maintain in their arguments. That's basically what they're saying. And the lack of metadata as to the legal workflow chart, of course, provides no antidote or answer. So there's a bundle of problems that taken together create a real problem. In terms of details and more detail about our difficulties, can I pass you on to Sophie Menegon, with your honour's leave?
Absolutely. Ms. Menegon, you have the floor.
Thank you, Your Honor. So first, with regard to the identification of prosecution witnesses, indeed, we have a difficulty because we have identified so far 124 witnesses who have been given a witness number. And so today I understand that actually it doesn't mean that the prosecution intends or not to rely on them for the trial, but we have been disclosed also very numerous documents from statements, transcript of interview from other courts or investigative entities. And I think the amount of persons who have provided a statement disclosed as incriminating evidence is more than 200. So that's why we are asking as soon as possible for a list of at least potential witnesses who may be called by the prosecution to testify in order to focus our investigation, because otherwise now we would have to investigate maybe 300 persons. It's really too much and also probably unnecessary, and will also slow down the trial preparation. Indeed, before the other court, for instance, at the ICC, when the prosecution would disclose documents relating to a witness, they would allocate a witness number and a category incriminating or exculpatory. So we would have a better idea of who may be called or not. Now we are really at loss for this issue. So we request clarification, and not just a few months before the start of the trial. We request clarification now. With regard now to the identification of material linked to each witness, indeed we have a difficulty because for now, the only information given to us is that in the description field of the document in legal workflow, the prosecution would add the pseudonym of the witness, la witness number 123. But when we read the statement or transcript of interview of the witness, we see that there are shown several documents, or they bring documents given to the prosecution, and we are not necessarily disclosed at the same time these documents or with the witness number. For instance, for some witness, there is no reference to the documents they have given to the prosecution, or there is a reference which is incomplete, or there is a reference, and when we search in legal workflow, we don't find it. So the document has not been disclosed to us. So what we request from now is that the prosecution systematically, with each statement and transcript of interview of a witness or an accused actually, disclose all the documents given by the witness or commented by the witness, and that they put in place a link with such witness. For instance, in legal workflow, it's either in the title of the document given by the witness, etc., or a new category, a new metadata in legal workflow with the link to the witness. Because now we are losing a lot of time to try to identify the material relevant to each witness. And this is something really easy to do for the prosecution, which would help the defense to be more efficient and to be ready at an earlier stage. Because in other courts, we had an easier way to find a connection between document and witness. First, it was the description of the document in the title of the document, but we had also the chain of custody, which was complete, like from such witness to such SPO investigator. And the third way was that the prosecution at the time of each disclosure package would submit an official filing mentioning that today it's disclosing such number of documents relating to such witness. So for us, it would be also more helpful to identify the relevance of the material disclosed. So that's also why we reiterate today, and we understand the position of the prosecution. We disagree regarding the relevance of more detailed chain of custody. We would like a more precise chain of custody linked to each document. For instance, there is one witness. I can give the witness number if you think it doesn't need to be confidential, who has brought with him or her some death certificate of his family member. But in a legal workflow, these death certificates are not linked to the witness. I was just able to find the link thanks to the search with the last name of the witness. And it would have been quicker for me to identify this document if in the chain of custody it was indicated like a document given by the witness to the prosecution. In legal workflow, it's mentioned that it's a LEX document, while we know these documents have been given by the witness himself. So this is the type of issue to which we are confronted, which really slow down our work in reviewing the prosecution material and also focusing on our investigations. I thank you.
Thank you, Ms. Ménégon. Before giving the floor to the SPO to respond, I would prefer to go through all defense teams, and then you will give a consolidated response, Madam Prosecutor, if you don't mind. Mr. Emerson, please, you have the floor.
Your Honour, may I say, first of all, that I entirely associate myself with the overview of the difficulties presented by Mr. Hooper and the more detailed analysis of some of the specific problems, which I think are just given as examples by Ms. Menon. The situation, broadly speaking, is this. The way in which the disclosure exercise is being conducted is the most unhelpful way possible for enabling the defense to begin effective defense investigations. It is indiscriminate, it is disorganized, and it is, frankly, at the receiving end, a chaotic amount of information that needs to be sifted and analyzed in order to reconstruct what is or may be the prosecution's actual case that we have to meet and therefore begin investigating. I don't want there to be any misunderstanding about the enormity of the hurdle that is being created by the manner in which the prosecution is carrying out its functions. There are two possible readings to this. One is that they are extremely incompetent. I don't think that's correct. The other is that this is deliberate, and one sees to some extent the echo of that in the submission by the SPO this morning, that linkages will need to be suppressed until a later stage. We understand the need for witness protection, but what we do not understand is why we are expected to reconstruct the prosecution's case from an indiscriminate volume of material which may or may not be relied upon in order to begin the process of our investigations. And there should be, again, no misunderstanding about the knock-on effect this is going to have for the earliest date at which this case could conceivably be ready for trial. Let me make it clear how we put this. Obviously, Your Honor, you were presented with organized material, presumably with some cover notes explaining the prosecution's thinking and linking the evidence that was presented to you in a coherent fashion to assist you in reaching your decision on confirmation. We, on the other hand, have no pre-trial brief from the prosecution. And as you heard on numerous occasions, the prosecution wants to avoid giving us its pre-trial brief until the very last moment before trial, to the extent of having submitted to you that if the trial date goes back, so too should the pre-trial brief date go back, even though it could be ready as early as May or June of this year. Indeed, it should be ready, or some guide should be ready now. The prosecution knows what its case is because they put it before you at the confirmation stage. What they're doing with us is unloading their database, having redacted important information that is necessary to enable us to understand it, and burying the relevant evidence amongst a mountain of material that may well be completely irrelevant. The consequence of that, I mean, this is not defense moaning or procedural nitpicking. The fact is, the consequence of that is that what the defense has to do, and the only guide that the defense currently has to what the prosecution's case really is the indictment. And so we are required to sift through vast volumes of material to try to figure out precisely what the prosecution is trying to allege here. There are, on our estimation, 34 different crime sites in the indictment. And of course, each of them has its own chronology. None of that even has been properly analyzed by the prosecution. There is simply no guide through this morass of material that would enable the defense to properly prepare an investigation brief. We have an investigation team which has been on standby since the 1st of January. And I now anticipate that it will take us until probably the end of March or mid-April to be able to have reconstructed from the material that has been dumped on us without any guide at all, a proper analysis of what the prosecution's case is probably going to be, and therefore how to brief our investigators to carry out their task. I don't, as I say, I don't know whether the prosecution has simply lost sight of the fact that the efficient management of this case requires the defense to be able to investigate effectively, efficiently, and in a manner that is focused to what the prosecution's case is. I don't know whether what is happening here is that the prosecution is so focused on the notion that the 4 accused must be convicted, and all defense, all prosecution witnesses must be redacted and over-redacted if necessary, in order to make it as hard as possible for these accused to be effectively defended. I don't know if that is what is driving Mr. Smith's overall guidance of this case. But I have to say that as the person ultimately responsible for the prosecution strategy, he has some questions to answer, and it should be he who is standing up in court today trying to defend what is an extraordinary, and in my experience in international criminal justice, unprecedentedly chaotic manner of disclosure to the defense. So I say that by way of background. Mr. Hooper described it as the absence of a route map. That's a polite way of saying that a vast amount of material has been dumped on us, and that we are trying to sift the relevant from the irrelevant, the possibly witness the prosecution will possibly rely on from those that they won't, and try to reconstruct how they put their case. Your Honour will understand from his own analysis of the evidence that the case against, for example, my client, Kadri Vasily, is wafer thin. It is based on the evidence so far disclosed against him is almost non-existent. There is almost no mention of him in the evidence, and there is no mention at all of him in the evidence committing any criminal activity. So this is a case which is built out of tissue in an attempt to try to erect a joint criminal enterprise out of a multiplicity of different events that the prosecution are trying to link together. Now that is the paradigm example of a situation where you need to have a very clear understanding of how the prosecution is trying to put its case, because you don't have any direct evidence against a particular individual accused disclosed at all. It is all going to be based on inferences said to be drawn from the totality of the events that occurred in 34 different locations in which he was not said to be directly participating or even present. And so I don't want to underestimate the injustice and incompetence of the way the prosecution is handling this. It's not simply a question of management day to day, or linking up witnesses with exhibits, or properly filling in the form that cross-references witnesses to what it is they're said to say. These are all details. The overall problem is, if the prosecution really knows what its case is, why don't they tell us? Because until they tell us, we are simply in the dark. Now, of course, what we're required to do by the way this case is being conducted, and it is being conducted in an extremely inefficient manner, what we're required to do is to start the process all over again, to take this huge volume of material, to go through it and read it all, every word, again, to start with. You can't use search terms to analyze this material. Obviously, we've done that for Mr. Vasily, and that's why I'm able to say to you there's not a single scrap of evidence against him of a commission of a crime. But beyond that, you have to read every single word in order first to understand what the prosecution is, what is the base from which the prosecution might be trying to select material to put a case together. Then you've got to guess at what kind of case the prosecution is trying to put, and how out of this vast morass of material they intend to confect a candy floss joint criminal enterprise. Now, those are significant hurdles to overcome. Of course, they'd be assisted if the prosecution wasn't trying to put back the date for its pre-trial brief to the latest possible moment, because that's the date at which they have to pin their colours to the mast and explain how out of this vast morass of crimes committed by other people, they're trying to build a case against, in my case, Kadri Vasily, because there isn't one. So the question I need to understand, and I'm asking it directly here now to Mr. Smith, and I'd invite him to stand up and answer it, is how could it be that the defense are in a position to investigate this until the prosecution nails its colours to the mast and explains out of this huge number of events precisely right now, here today, how it says this case is alleged to prove the guilt of these four accused. Because if they're not able to tell us that, then we all need to reckon with the fact that the defense are going to have to construct what they imagine the prosecution case to be, out selecting some relevant from irrelevant material with no assistance from the prosecution, no guide, no organization, and then try to investigate what they think the prosecution case is going to be, only to find when the prosecution files its pretrial brief, it probably is a different case, in which case we'll have to start all over again. So I don't want there to be any misunderstanding here. We as defense counsel from the British bar, and that accounts for quite a number of us, have obligations of ethical responsibility to ensure that we do not participate in proceedings that begin to slide into a fundamental denial of justice. Now, if this case carries on in the manner in which it is currently carrying on, with and with the prosecution continuing to absurdly suggest a date of trial for September, we are in a very difficult position. You will put us in a position of professional embarrassment, and that, I'm afraid, is not a position any of us wants to be in, because the consequences could be extremely serious for the conduct of these proceedings. It is time, with great respect, Your Honour, for you to get a grip on the prosecution's misbehaviour. Every single decision that they've taken, and we've heard them announce them this morning, we've heard them announce them in every status conference, is unquestionably, objectively designed to make defence preparation more difficult. And the only inference I can draw from that is that the prosecution knows that it hasn't got a case, or at least hasn't worked out what its case is yet, and is in a position that it wants to run this to the last possible moment before the absence of the case is properly analysed and disclosed. So I would invite Mr. Smith to stand up now and explain how he expects the defence to conduct or even begin effective investigations, and why he has not been willing to state in clear terms precisely which of this evidence is relied upon and how it is said to prove the guilt of the accused. Those are my submissions. And in answer to the question, when can the defence investigation begin, which is on your agenda, the answer to that is, how long is a piece of string? When are the prosecution going to get their act together and actually understand that they are ministers of justice designed to assist fair proceedings, which means assisting the defence fairly to answer the allegations against them and investigate them properly according to the genuine requirements of due process. We've heard the prosecution say numerous times, oh, we are deeply concerned to ensure the fairness of these proceedings to the defence. I'm sorry, we do not believe that. As far as I am concerned, every decision and every methodology adopted by the prosecution is a kind of tactic that in my jurisdiction would incur the censure of the court. The court itself at this stage would be intervening and calling the prosecution to account for why it is making the situation of defence preparation so difficult. I'm putting this on the record now. I want to make it clear the prosecution took the opportunity of this status conference to go beyond the agenda that you had set and yet again reiterate a ludicrous trial date suggestion. And they're doing that whilst at the same time making even the beginning of the defence investigation impossible. Why are they doing that? I leave the inference for others to draw, but why did they choose to go beyond the status conference's agenda to reiterate this absurd trial date suggestion when you yourself have just ruled in the provisional release applications that it is premature? And I know for other reasons that the position of the KSC generally is that the trial date must be fixed with the needs of the defence taken into account, and that it's well too early to decide on that at this stage. It will remain too early to decide on that until the defence understands the case they have to meet. So what the prosecution begins...
Mr. Emerson, and because it is too early, it's exactly the reason why I would like the parties not to raise this issue today.
Exactly.
Please.
Exactly.
So if you can...
I'm not raising it. I'm responding to the fact that the prosecution have raised it beyond the scope of the agenda. I'm simply saying all the indications here are that this prosecution is not being run according to the basic principles that should guide a prosecutor, which is that the proceedings must be fair and intelligible to the defense, that the accused must clearly understand the case they have to meet, and that they must have a proper opportunity to investigate and prepare their defense. It is patently obvious to me, as somebody who's practiced and sat as a judge in this field for many, many years, that the conduct of the prosecution here is designed to railroad the defense into a trial where they are not properly prepared. And I'm afraid I have to say that in my jurisdiction, that would be regarded as unethical conduct that would be controlled by the court at a very early stage. Those are my submissions.
Thank you, Mr. Emerson. Now I turn to Mr. Young. Please, you have the floor.
Thank you, Your Honour. Your Honour, in the light of the detailed and cogent submissions which we have just heard from my learned friends, Mr. Hooper and Mr. Emerson, I have nothing to add. The submissions won't improve with repetition. Your Honour has our written submissions on disclosure, and we stand by them. That's all I say this morning. Thank you.
Thank you, Mr. Young. Ms. Alagendra, you have the floor.
Your Honour, may I defer to counsel Mr. Ellis to address this matter of disclosure?
Absolutely.
Your Honour, the issues that have been identified cogently this morning by other defence teams are ones which affect us all. All teams are equally handicapped by the way in which disclosure is being carried out in this case. And so I won't repeat the submissions, but we join very much with what has been said already by other defence teams this morning.
Thank you, Mr. Ellis. Now I turn to the prosecution. Madam Prosecutor.
Thank you, Your Honour. The Vasily defence has just spoken with extreme generality about a purportedly chaotic volume of material that has been dumped with no guide. That is simply inaccurate. Indeed, the Vasily defence submissions appear to be nothing more than rhetoric. It is also a continuation of what we would submit to be inappropriate and overly personalised submissions that we have repeatedly heard from the Vasily defence in multiple status conferences and which should not be tolerated before this court. The defence has, in fact, been provided with a very specific guide to the disclosed material in the form of the Rule 86.3b outline, which is precisely the guide which the pretrial judge received when assessing that same material. Moreover, the materials are being disclosed pursuant to specific rules which clearly indicate whether the material is being relied upon by the prosecution. We will be happy to return to comments on the status of preparations and investigations at the relevant agenda item. With respect to the Thaci defence submissions, I believe that I actually addressed each of those points in my initial remarks. The statements which have been disclosed are statements which, in the vast majority, we do intend to rely upon at trial. Further, in due course, all other materials, such as exhibits referenced in interviews, will be disclosed in accordance with the outlined schedule. And with regard to the Thaci defence's reference to a summary of each witness, I believe he is referring to the type of summary that will be disclosed in accordance with Rule 95.4 at the appropriate time and in accordance with the timeline to be established. Thank you.
Thank you, Madam Prosecutor. Does any of the defense team would like to reply to the prosecution? If so, please wave your hand. Yes. Mr. Hooper, please.
Am I unmuted? I think I am. Yes, I am.
We can hear you. Please proceed.
Right. Well, you know, I hear Ms. Lawson say that she's addressed our concerns at the outset. She hasn't. The issue is a straightforward one. Can we have better and fuller details of the material that is being disclosed to us? Can we have a connection, clear connection now between a witness statement and any exhibits relating to that witness? Can we have the necessary connection between matters that's shown to potential witnesses in the course of their interviews when that material is disclosed to us? I don't think any of what I've heard this morning from Ms. Lawson addresses any of the fundamental issues that we've raised. And it's come to the point where I think Your Honour has to intervene in order to help the prosecution, essentially, create a systematic approach to this that is genuinely helpful. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
I would just like to respond very briefly to the accusation just leveled at me that I've made inappropriately personalized remarks that ought not to be permitted. Unless there should be any misunderstanding, my submission, and we can call it a frontal attack if you like, on the conduct of the prosecution, is not directed at any one individual member of the prosecution, except that Mr. Black is the prosecutor and is therefore responsible for ensuring that the prosecution conducts itself in a manner which is consistent, not just with the rules in minute detail, but with the need to ensure justice to the defence, to ensure a fair trial, which is a principle that clearly the prosecution has lost sight of. And that is not, as I say, a personalised attack in any way. I am calling on him to stand up and take responsibility and explain precisely what is going on and why the defence are being repeatedly put in this difficulty. And I am calling on the judge, on you, Your Honour, to take action because as the way the system works is obviously that the judicial role is entirely independent and is intended to exercise constraints on both parties to ensure that justice is done. And when it becomes apparent, as it is now apparent, that the prosecution has a policy of conducting this case to make it as hard as possible for the defence to investigate and meet the allegations against them within the proposed time frame, it is time, with respect, as Mr. Hooper says, for the independent judiciary to intervene and start to put them straight. Because if that doesn't happen, one can see this trial becoming derailed by the time process. None of us is anxious for this case to go on for years in the pre-trial stage. And equally, none of the British Defence Council are able, under their ethical guidelines, to participate in a trial that is flagrantly unfair because of the timeline that's involved. So a line needs to be drawn, which is reasonable down the middle. We are not discussing times today, but what I said was not intended and should not be read as a personal attack on anyone. It's a collective attack on the prosecution for the manner in which, as a matter of policy, they've clearly chosen to conduct this case. And the reason why I singled out Mr. Black is because he's the prosecutor, and we've heard nothing from him to justify the way in which the case is being misconducted. That I just wanted to clarify. There's nothing personal about it.
Thank you, Mr. Emerson. Mr. Young or Ms. Allegendra, do you want to add anything?
Thank you, Your Honour. Simply this, Your Honour will have seen in our submissions that we filed in writing that we indicated that we had cooperated with the other parties to see whether there could be some agreement, particularly in relation to Rule 109C and the categorisation issue. But Your Honour will have noted that the time has come really when we implore Your Honour to make a decision, because it's an important decision for the benefit of the parties. So I'm just reiterating it's very important, Your Honour, with respect, that Your Honour makes a decision on this.
Absolutely, Mr. Young. It is an item in the agenda today, so we'll come back to that in a couple of minutes, and I agree with you. This is probably an issue that is very much linked with what has been discussed now, and it's certainly a way to clarify the case in the benefit of everyone. If there is nothing to add on this matter, unless the SPO wants to take the floor? Yes, Madam Prosecutor. And briefly, please, for all the parties, because it's already 10 to 12.
This will be very brief, Your Honour. I just want to note that lines to be drawn must be based on accurate information, and the Vasily defence's submissions that they were left without a guide to the material were entirely without foundation. Finally, I would note that the specialist prosecutor's name is obviously Jack Smith and not Mr. Black. Thank you.
Thank you, Madam Prosecutor. I don't see any defense team asking for the floor, so I will move to the second item in our agenda today, which is the translation of the Rule 86.3b outline. I have been informed that the translation of the outline is in progress, and I thank the registrar for her filing on this issue. I would like to hear from the registry whether an estimate can be provided on when the translation will be completed and on any possibility of speeding up this process. And I would also like the registry to inform the court if there is any possibility that a smaller portion of the outline could already be provided to the defense, as requested by some defense teams, before 20th April 2021. Mr. Roche, you have the floor.
Thank you very much, Your Honour. As Your Honour has already noted, a filing was submitted on the 8th of February, reference number 192, and I would refer the participants to that filing. The translation of the material in the 86.3b outline is being granted the highest priority by Language Services Unit within the registry. A total of 6 translators, including revisers, are working on this material. The material is approximately 620 pages, and obviously that is a very significant amount of work. It has been, as I said, granted the highest priority, and it is estimated that all of the work will be translated and revised by the end of May 2021. In response to the request, we are also ensuring that we will provide portions of the material when it is available, and we currently anticipate that 150 pages, approximately 1/4, will be fully available or revised and translated no later than 20th of April. These are indicative timelines. They are realistic professional assessments based on the experience of Language Services Unit. And while we would hope that there may be some limited scope to bring the date forward, obviously the quality and professional requirements are such that it is a time-consuming exercise. So I, in conclusion, would say that the full work or the full material will be available no later than the end of May, and the first tranche of approximately 150 pages should be available no later than the 20th of April. Thank you very much.
Thank you, Mr. Roche. Does any of the defense team wish to take the floor on this issue? Mr. Young, you have the floor.
Your Honour, thank you. It's simply to say this, Your Honour, we appreciate the submissions of the registry in relation to translation. Obviously, in a case like this, where an official and important language is Albanian, it's absolutely critical that the defence have the documents translated into the accused's own language so that they can understand, read and consider the material in good time, and so that the defence lawyers can also understand the position too. Now, Your Honour, the registry have just indicated that, in fact, this is given high priority, and I've talked about May, the end of May, in relation to this document. As Your Honour appreciates, this is one of the most important documents that the prosecution have served on the defence. This is but one document. There are thousands and thousands of documents. When it appears to be the case that one priority document may not be available until the end of May, possibly, and it will not be until then, that the accused will have in their own language, a translation that they can read, is hugely concerning. I appreciate it's a time-consuming exercise, but this simply goes to demonstrate very vividly and very clearly the issues that we're facing in terms of the timeline. That's all I say.
Thank you, Mr. Young. Mr. Ellis, you have the floor.
Thank you, Your Honour. This is also an issue of particular concern to Mr. Krasniqi. He doesn't speak or read English, and therefore this isn't just some procedural matter. He really needs that document in Albanian in order that he can begin to appreciate and give instructions on the case that's being asserted against him. And I do place on the record at this stage that this seems to be a part of what is capable of becoming a broader issue affecting these proceedings. There are around, I think, 289 filing items in the case at the moment. Out of those, around 65 have been translated into Albanian. The documents that have been translated include things like the relatively short notifications of attendances at status conferences, and the documents which have not been translated into Albanian yet include important decisions like Your Honour's decision confirming the indictment, like Your Honour's decisions on interim release. And so we would say at this stage, it's important that important decisions in the case are prioritised and translated into Albanian, and particularly that the outline document is translated as early as possible.
Thank you, Mr. Ellis. I don't see any parties or participants requesting the floor. I will just mention two things. The first to the registry is, should the outline be translated earlier than expected, or at least a segment of it, of course it would be much appreciated that this could be sent to the defense team as soon as possible. And I also invite the defense teams to link up with the registry for prioritization, as Mr. Ellis just mentioned. If there are filings that are critical or more important than others, I think it's an important practice to inform the registry so that this, if it is possible, can be prioritized in terms of the translation workload. Unless nobody wants the floor. So I will move to the third item on our agenda today, which is the issue of the Rule 109C charts. It is actually linked with the first topic that we discussed, so I will not invite the parties to repeat everything that has been said, because I think a lot have been said already in terms of the difficulties of the defense and the disagreement with the prosecution on this. But I would like us to stay focused really on the technical aspect of the charts, because this is certainly a way to respond to the debate that we have today. I take it from the parties' written submissions that there is no agreement between the SPO and the defense teams regarding, first, the level of subcategorization of the disclosed material in the chart, notably the question of including such subcategories as the relevant count on the indictment, the relevant underlying crime, the locations, which accused it concerned, or which modes of liability it refers to. The second disagreement is the categorization in the metadata fields in legal workflow with respect to each item disclosed. The third disagreement is the category of material disclosed that should be supplemented by the Rule 109C chart, notably if it shall also include exculpatory material. And the fourth disagreement is the frequency in which such charts are provided, for instance, for each disclosure batch, or only when or after pretrial briefs are filed. I also invite the SPO to give submissions on the impact on the defense proposals, of the defense proposals to the disclosure calendar, notably if it is to include subcategories and if such charts are to be provided with each disclosure batch or in a more regular basis than what the SPO proposes. Madam Prosecutor, you have the floor. And please, if I may ask to all the parties to be as succinct as possible and really to focus on these technical aspects that I just mentioned. Thank you.
Your Honour, I don't have a significant amount to add to our prior submissions and written filings on this matter. You are correct that there has been no further agreement, and further progress is unlikely at this point. I do want to clarify one point. The format of the chart itself is in principle agreed between the parties, I believe, including in respect of the counts, the locations, the crimes, the modes of liability, all being included in the chart that would be provided according to the SPO's proposal at the time of the pretrial brief. What is not in agreement is providing that further subcategorization at the time of each disclosure. The proposal which the SPO has put forward mirrors and is consistent with the requirements of Rule 109C. The question that remains is what is practicable, and unfortunately we are unable to do the further subcategorizations in a manner which is consistent with fulfilling our core functions in this and other cases. With respect to the defence's further submissions that they in writing, I would just note 2 points. First, the defence has received the Rule 86.3b outline, which in respect of the vast majority of material already disclosed provides detailed information on each of those categories, including by reference to the charges, the crimes, the locations. Second, the Salimi defence submission that the subcategorization work could effectively have been done in the time that it has taken to litigate it is not correct. I wish that were the case, and if it were so, we would have certainly done it. However, preparations for disclosure did not start at the date of the initial appearance, but well in advance of that. And as a result of those preparations, we remain on course to meet the deadlines set out in the framework decision. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please. Mr. Hooper, your microphone is mute. It is still mute. It is still mute. Now it's fine.
Thank you. So the prosecution is saying we don't want to do it their way. We want to do it our way. We can do it. They can do it. They don't want to do it now. They've got a system which has now been in place for, well, probably before the confirmation of the indictment. And they don't want to depart from it. Well, I hope they're not applying it to other cases. Mustafa is certainly not applicable to this case because it's so radically different. The core function of disclosure is surely to assist the defence in finding its way through the evidence. The Honour wishes us to address the technical matters. Ms. Menegon, can I ask you to add any technical observations that there might be? Thank you.
Ms. Menegon, you have the floor.
Thank you, Your Honour. I don't have much to add to our written submissions because we reiterate our previous submissions. I just want to stress that indeed for us it's very important to get a detailed chart at the time of each disclosure package, because as we have noted, we are missing for now some information to connect the document to the witness or eventually to the charges. So this would really help us to focus our review of the material and our investigations. The prosecution is saying that we don't need a chart now, I mean, at the time of each disclosure package, because we have the SPO outline, but this is a document of 600 documents. We may have 300 witnesses to review and like more than 3,000 documents to review. So it's really, of course, difficult for us to make such a connection. And that is why, since the prosecution is saying he has already made a kind of connection between the evidence and the SPO outline, to do it at the time of each disclosure package. I thank you.
Thank you, Ms. Menegon. Mr. Emerson, please.
Your Honour opened this agenda item by commenting that it is to some extent connected with the first item on the agenda, and I would certainly endorse that in the sense that the absence of detail in the schedule and the compliance by the prosecution with 109C obligations is of a piece with the obstacles that are being presented to the defence preparation. May I simply say this? I want to focus on one aspect of the schedule. You will know that in previous hearings, I have taken a very light touch in relation to involvement in the scheduling process, because I anticipated that when the prosecution's evidence was disclosed, it would be disclosed in a form sufficiently coherent for us to be able to know immediately what the prosecution case was. The schedule obviously is a second best way of doing that. It's a clue to at least to which witness, or should be, to which witness relates to which incident, relevant to which place and count on the indictment. And so I want to just focus on that one issue in relation to the schedule at the moment, the first of your four disagreements, as you outlined them a moment ago. May I stand back from that for a moment and look at what it means? I said earlier on that a large amount of material has been dumped on the defence without a guide, and Ms. Menon took me to task and accused me of being unfair on the prosecution. But let us just take this one example. Material is disclosed in large quantities, but the prosecution, who must know, this is the thing that I find difficult to understand when the prosecution talks about this obligation to disclose being incompatible with its core functions. Indeed, the prosecution must know what the witness is relevant to. They must know which incident, which place, which particular event it goes to, never mind which count on the indictment, because the indictment counts, of course, are catch-all counts, which deal with incidents that took place in 34 different locations. They must know themselves, because otherwise they wouldn't be producing the material in the way that they are. Reeling back to what I said earlier on, when the case was put to you for confirmation, I don't know, but I assume that you were given some guide through the material beyond the indictment. And I say that because there's a very different practice in this tribunal to the other tribunals that I've experienced in terms of the detail that's provided in the indictment. The ICTY indictments very much represented something that looked like a pre-trial brief. So you'd have the counts, each incident would be separately identified, it would be described, of course witness names might be redacted, but you would have a full explanation of the relevance of each witness to each allegation. Here we have none of that. And the prosecution's indication is the first time we will get that guide is when they serve their pre-trial brief. Not just because that's when they will give us their pre-trial brief, but also because that's when they'll fill in the holes in the schedule. They won't do it before then. Now, is that because they don't know? I find that, again, hard to believe, or what the connections are, or is it because they're withholding that information from the defense? It doesn't very much matter, because either way, the defense can't start work on investigations till they know what the prosecution case is. So just on that first disagreement that you identified as a technical issue, I don't I don't really recognize this as a purely technical issue in the way that perhaps it's being approached by the prosecution. I regard it as an issue going fundamentally to the justice of these proceedings, not solely the categorization, but the lack of a proper description of the prosecution's case. And I want to put in light of the position that the prosecution takes, which is, as I say, it's incompatible with the SPO's discharge of its core functions, which I take to be a resources argument. What that says is the prosecution is nowhere near ready to state its case yet. And if that is the position, then what I would like to suggest to you, Your Honour, is that you order an early date for the service by the prosecution of its pre-trial brief. In other words, the prosecution to serve its pre-trial brief by beginning of April. Of course, it can be amended prior to trial if new evidence emerges, but the prosecution serve its pre-trial brief by the end of March, beginning of April, together with filling in the gaps that are being deliberately withheld from the information we need in the schedule, because they say the two are pegged. And then we can start talking about defense investigations and planning for trial. But you are, at the moment, the prosecution is putting us in the position of walking into a blizzard and trying to find our way from A to B without a map. And so the time has come for the map. And if they won't do it through the schedule, which in any event is very much a second best way, that the right solution is for you to order them to provide the sort of guide I assume they provided to you during the confirmation process in the form of what the rules provide, namely a pre-trial brief, and to order that to be served on the defence in its initial form on the 1st of April. And thereafter, obviously it can be amended as the prosecution achieves additional evidence if it does. And I'm formally tabling that proposal in response to this item on the agenda. Those are my submissions.
Thank you, Mr. Emerson. Mr. Young, please.
Thank you. Your Honour, we have nothing to add to our written submissions. We would respectfully submit that we've reached an impasse and the time has come for judicial intervention and a decision on the issue. For otherwise, we won't move forward. Thank you.
Thank you, Mr. Young. Ms. Alejandra or Mr. Ellis?
Your Honour, Mr. Ellis will address this issue as well, with your leave.
Thank you, Ms. Alejandra. Mr. Ellis, please.
Your Honour, we too have addressed this issue in our written submissions and we stand by them. I will supplement them only by saying this. You have heard, Your Honour, the general complaint of the defence teams that the way in which material is being dumped on the defence is unhelpful to defence preparations. This rule is a specific example of a way in which the prosecution could improve upon the position and actually provide the defence with some useful assistance in navigating the amount of material that has been provided. But for some reason, the prosecution don't appear to want to do that until a pre-trial brief, which they are saying will be provided in quite some months' time. In our submission, the material should be provided, the further subcategorization should be provided with each disclosure package, and the defence need it at that point in order to be able to make use of it for investigations and for understanding the material that is provided. In addition to that, we rely on our written submissions, Your Honour.
Thank you, Mr. Ellis. Now I turn to the prosecution, and I would specifically like to hear you on two things. The first one is the questions that I initially had in the introduction of this topic, which is what concrete impact it would have on the timeline. That's an important point. And if you could address the different disagreement, maybe not all of them, but at least if it was to be requested that we add subcategories, or that these Rule 109C chart be provided more regularly, whether it's with each disclosure batch or before the pretrial brief. And second, I would like you to raise the issue or the proposal made by Mr. Emerson, which is to issue a pretrial brief earlier than you projected, so as to allow the defense to benefit from the Rule 109 chart. You have the floor, Madam Prosecutor.
Thank you. I believe it was the Salimi defense is correct that we have reached an impasse, and it is an impasse between the ideal and the practicable. The SPO proposal made is compliant with the requirements of Rule 109C, and what we are now discussing is what can be done above those requirements. And we are making a resources argument, and we're making that because that is exactly the basis for what it is practicable for the office to do. In respect of the Vasily defense submissions, I would also refer him again to Rule 86.3 and to the record of filings in this case, which are available to him and which contain our Rule 86.3b outline, which was provided to the Chamber and has been provided to the defence teams. Turning to the questions that Your Honour specifically mentioned just now on timing, the subcategorization with respect to Rule 102.1b material is dependent upon the preparation of the pretrial brief, and in light of the timeline that has been set, it will be several months before that is at an advanced stage, which would facilitate generation of the chart from that. And the chart was designed and proposed specifically with that in mind. With respect to Rule 103, it is true that I've been unable to give the Chamber a specific indication of the degree of delay that would result, for example, in terms of a number of months. And that is because the task in question is one that we simply cannot do while continuing to meet our core functions, including core disclosure obligations in this and other cases. In order to conduct such an exercise in a manner which accords with the requirement that exculpatory material be disclosed in a prioritized fashion, it is literally the case that almost no other work in the office across all cases would occur for a significant period of time. I believe that addresses the questions, but if there was anything that I missed, I'm happy to.
Thank you, Madam Prosecutor. I don't see any defense. Yeah. Mr. Emerson, please.
I just note that there was no response to the suggestion that the prosecution should be ordered to file its pretrial brief in its initial form on the 1st of April. Can I just add one thing? And I am making that formal request to you, Your Honour, today. May I just add one thing? It is clear that the prosecution says that compliance with the obligation that we are requesting in relation to the first item, namely a particularization of the place and date and so forth of the incident concerned, it is clear that as a minimum that the prosecution regards that practically and on a resources basis as being inevitably linked to the date of the pretrial brief. So be it. If that is in practical terms the reality, then we need to work with that reality. But when it is said by the prosecution that providing that information to the defence would be incompatible at this stage with the performance of its core functions, I'm afraid this is a moment for judicial intervention to remind them that their core function is to state their case clearly to the defence. That is one of their core functions. And it seems that the prosecution is slightly lost in process and has lost sight of the fact of what really is their core function. Their core function here is to enable the defence to understand the case it has to meet. So since no direct response has been given to that, I'm not going to invite you to infer that the prosecution has waived its right to reply, because it's too important an issue, namely the bringing forward of the date of the pre-trial brief to be dealt with in that way. I note that you specifically asked for a response and didn't get one. And I'd again perhaps give the prosecution the opportunity to provide a response. But when it's said we can't give you weeks or months or days and how long it would take us to fill in the form, then I'm afraid that they're saying to you, we need judicial intervention. We can't tell you when we're going to be ready. So it is time, I'm afraid, for you to impose a date upon the prosecution to state its case, which is what this means. And for that purpose, since the prosecution has said that we can't fill in this form accurately until we have completed our pre-trial brief, I understand that, because they want to formulate their case before they actually say which witness is relevant. Fine. Let's bring both dates together forward to the 1st of April, and then the defense can get on with the job of investigating, and we can look at a trial date realistically at that point once we have the prosecution's pre-trial brief. I mean, that is a practical and sensible way of proceeding. And I know the prosecution will say, well, we can't be ready for that in that period of time. But I'm afraid it's necessary for a judge in this situation to crack the whip on the prosecution a little. They've had 5 years to prepare their case. It's rather surprising that they haven't got a draft pre-trial brief ready now. I imagine that with a little effort, they would be able to have a draft brief capable of being amended by the 1st of April. And that would speed matters up immeasurably. It would make these proceedings efficient. It would give you and us an opportunity to plan for trial date. But without that, and until that happens, we're all wading around in the mud. So I would really respectfully suggest that submission requires a rather more detailed response than being brushed off by the prosecution without an answer.
Thank you, Mr. Emerson. Ms. Lawson, do you want to respond to Mr. Emerson on this?
Yes, Your Honour, just briefly, thank you. It is clearly inaccurate that the prosecution has failed to state its case. We have done so very clearly in the indictment and in the Rule 86 3B outline, which for the third time I am inviting Vasily Defence Counsel to read. As for the timing of the pre-trial brief, we will be happy to address that at the relevant item in the agenda. Thank you.
Thank you, Madam Prosecutor. We will now then move to the next item in the agenda, which is the SPO investigations. I now turn back to the prosecutor to ask about the status of its ongoing investigations. Could you confirm your estimate of July 2021 or earlier for when you will be able to file your pretrial brief in light of the protective measures decision and the disclosure calendar? And I stress that I do not invite the parties to give submissions on the date of the commencement of the trial today. I would like the parties to stick to the next steps, and for the SPO, it will be the pretrial brief. Madam Prosecutor, or Mr. Prosecutor, sorry.
Thank you, Your Honor, and good afternoon. I would like to start by stating that I have intentionally sought to be circumspect in addressing the court directly because I believe that the very able prosecutors who handle and lead our cases are best positioned to do that in most cases. So I can assure the court that this will not be a regular practice where I address the court on particular issues. That having been said, when an important issue comes to my attention where I believe it's incumbent on me personally to make the position of my office clear, I will seek to lay out the position and the support that I see for it. The issue of when the court will order a pretrial brief in this case, and while I will not address it in detail today, in our view, the inextricably linked issue of when the trial will occur are such issues. Now, as the court is well aware from prior status conferences and also today, there's strong disagreement, that may be an understatement, between the prosecution and the defense on these issues. And while I disagree wholeheartedly with the defense view, I absolutely support their right to make arguments. If the defense thinks it's to their advantage to get the pretrial brief earlier and have the trial later, that is completely in their right to make that argument. However, there is a difference between having the right to make an argument and having it win the day when it is not supported by logic or by fact. At previous status conferences, Your Honor, and this status conference as well, I have heard counsel for the defense seek to impugn the integrity of my prosecutors because of their arguments in favor of an expeditious trial date and a reasonable date for the pretrial brief. I ask this court to take a different approach because I have never believed that personalizing an argument improves it. Mr. Emerson talked about the jurisdictions he's practiced in. I was taught as a young lawyer that arguing louder or more aggressively or laced with personal invective does not make a losing argument a winner, nor does it do service to the maker of that argument. That is not how I practice law. That is not how my staff will practice law, and we will not engage on this level. I would, however, invite the court to note when it sees that happening in this courtroom, because it should be a sign to Your Honor that there are not facts and law supporting an argument. In this particular issue of the pretrial brief, if this court separates the merits of the defense argument from the inflammatory language and from the threats, and I say threats, Judge, twice this morning, Mr. Emerson's done it in the past, he basically threatened the court that he would not participate in these proceedings if he got rulings about the trial date that he didn't like. If the court gets past that and looks at the facts and the law, I think it will see that the prosecution's position is the correct one and supported by the facts and the law. Now, I want to make clear, we've made it clear in our filings, but I want to make it personally clear here today. It is an important and legitimate consideration to give the defense the time and resources they need to prepare for this trial. That is an absolute must. And it is in our interest, as much as the defense, that they have that time and that they have those resources. But this court has other considerations to consider in setting a trial date and in setting a pretrial brief. One is the victims in this case and the witnesses in this case who have waited years for justice. A second is the reality. A reality, we have been here for an hour and a half, a reality that has not been mentioned once today, that witness intimidation and obstruction of witnesses is a reality of this case, and it will be a reality going forward. And the plain, simple fact of the matter is that if there is a large gap between the entire disclosure of our case and that trial, that will endanger witnesses. That is a plain truth that in all of these issues we've talked about today has not been spoken. And yes, there are protective measures, and yes, there are redactions. But the court has to understand that those are tools to mitigate risk. They cannot reduce it entirely. And if these witnesses who have put their faith in this institution come to this courtroom, take that stand, and tell their story, if they are left for months and months and months between the time of the pretrial brief and trial, we are doing no service to them. I would also note on this issue, Judge, when we talk about the notice the defense has, Ms. Lawson's already addressed the degree of disclosure that we've given and that we intend to give and the schedule we intend to stick to. I would submit that the disclosure procedures of this court are as robust or more robust than any in the history of international criminal justice. They distinguish this court from previous courts. The defense can cite cases where trials took a great deal of time and where pretrial briefs were filed far in advance of trial. This court can do better. This court must do better for the witnesses and for the victims and for the people of Kosovo. I would also note the resources the defense have in this case, because it is unique. The defense has claimed at previous status conferences that they would need years to investigate the prosecution's case. The fact is the defense has as much resources as any defendants have had in a case like this. The government of Kosovo recently stated that they had set aside 20 million euros for the defense of the accused, and that is in addition to, of course, the separate funding that this registry has where legitimate need is shown. I understand fully that the court does not want to have the entire discussion about a trial date today, but I think today's discussion shows that we need to give this court, and this court needs to use every tool possible to manage this case going forward. And our position is that setting a pretrial brief date and a trial date together, giving all sides foreseeability and keeping the time between them consistent with other tribunals of approximately 3 months, that will be a management tool for the court going forward. If the court rules on these issues against the defense has made every indication that they will resist those rulings. The best thing, the most fair thing to do right now is to set dates that are foreseeable and can be worked on now. Otherwise, I fear that the defense seeking to delay this case is self-fulfilling. And again, I should note, I think very significant weight should be given to the history of witness intimidation in similar cases, a history that is acknowledged in previous filings by all parties to this court. The issue of when the pretrial brief should be filed is part of a range of issues, some of which we've discussed today. And in each of these cases, the defense has taken the position that history is the limit of the future, that what has happened in the past is the only guide for what we can do now. Just because things can take years to litigate does not mean they must. The length of proceedings, Your Honor, in international criminal justice has rightly and roundly been criticized as a serious problem. It hurts the credibility of institutions and the outcomes they produce. This is a very real and serious shortcoming, and this court is situated to address it. We should not have this ceiling be the basement. We should shoot for what this court was set up to do, to give efficient proceedings that people in Kosovo can understand. I have to say that I'm at a bit of a loss when I hear today from Mr. Emerson that our case is built out of tissue and that there's no evidence to the case despite the disclosure that Ms. Lawson has referenced. And yet, in the same moment, Mr. Emerson and his co-counsel argue to the court that they need years to prepare for a trial built out of tissue. That doesn't make any sense. At our first court appearance in this case, the very first one, Mr. Emerson gave a detailed, multi-pronged, factual, and legal presentation of Mr. Vasily's defense. This was done before he even had any disclosure from our office. Such a presentation would simply not be possible if the world were as the defense argues it is. The reality is the accused themselves have been aware of the gravamen of these charges for some time, and despite their protestations to the contrary, counsel are already well on their way to being prepared in this case. In conclusion, Your Honor, I would note that each of the accused has very publicly, very clearly, and very forcefully proclaimed their innocence of all charges. Now, I want to be clear, they were certainly not required to do so. And I also want to be clear that the burden of proof in this case is on my office, not the accused. that is as it should be and as we want it to be. That said, I find it quite curious to be standing here today before you, fighting to grant them their day in court, fighting to grant them their day to test our case, to put us to our burden. Your Honor, that is where we are. Your Honor, we would ask the court, consistent with our previous filings, to cite an expeditious trial date, but with respect to the issue the court's asked me to address, to set a trial date tied to a pretrial brief that is consistent with past history in similar cases and consistent with the needs of protecting the witnesses in this case. I would submit that setting a trial date with the pretrial brief is the best way to manage this case going forward so that a fair and public trial of the allegations of the accused can be had for the accused and for the people of Kosovo. And as it must, I am confident that this can be done in full respect of the defendant's rights. Thank you, Your Honor.
Thank you, Mr. Prosecutor. May I ask the interpreters if they can proceed for a couple of minutes so that we have the responses of the defense teams, and then we will have a short break before continuing the agenda, but I would rather have the responses of the defense on this issue now rather than breaking.
We can proceed, Your Honor, yes.
I will ask the defense teams for their responses, and please be relatively brief because the interpreters have been working now for a long time and they deserve a rest if they want to be as efficient and precise as possible. Mr. Hooper, please.
Yes, well, a moment ago, I was very happy to see Your Honour raise a yellow card to us all in respect of the issue of trial date. I was therefore more than surprised when Mr. Smith gets up and commits a deliberate foul in front of Your Honour. There we are. Now, I appreciate Mr. Smith probably came here this morning with a prepared statement, and he sees his role quite rightly as leading from the front. But perhaps a little more focus from him and from everyone else might assist the status conference a little more. Mr. Smith feels that his disclosure regime is the best of all possible worlds. Well, it isn't. I think if he put himself in our shoes, he'd quickly realize that. The disclosure is, as I think the point has been made already, less functional, less adequate than many of us have found in other institutions. So today we've been talking about ways of balancing that to assist us, not with the objective of putting off the trial date, which has become a bit of a mantra for the prosecution. It's untrue. It's merely to assist us in respect of mining the information of the case. And the suggestion has been made, well, given that all else has failed in terms of the prosecution system, we're still left with the ability of their chart to indicate to us in a helpful manner ingredients of disclosure that otherwise are missing. And the prosecution opposed that, as we've heard. And I think it was in that light that my friend for Mr. Vasily suggested, well, why not bring forward the pre-trial brief? And that's now degenerated into an argument that the pre-trial brief, according to the prosecution, is anchored to the trial date. But I don't want to go into that argument, merely to question this. Why can't we have a redacted pre-trial brief? If the concern is, as Mr. Smith says, principally one of protection of witnesses. And we know that this court, there's been a steady mantra long before any of us came into these cases, long even before the SPO came into these cases, of witness intimidation, witness intimidation, witness intimidation. I'm not going to go into that, but it's more a mantra than perhaps proper substance in reality in terms of the principal people that we're concerned with in this case. And this isn't a case about Mr. Vasily, by the way. It's a case about 4 accused, and not all of whom have had the experience perhaps of Mr. Emerson in terms of conducting cases concerning the facts of Kosovo. So where are we? I said I was very grateful to see Your Honor raise the yellow card in terms of trial date. And I know what Your Honor said today. You don't want it discussed. For our part, we merely want, that is, I think I can speak for all counsel, an assurance. Well, it's not an assurance, it's a reassurance, because we understand it's what's in Your Honor's mind anyway, but a reassurance from Your Honor that there's no question of discussing trial dates, and nor should there be, until the time is ripe, and that Your Honor will put us all on notice so that we will have an opportunity of contributing in a positive, fruitful way to that discussion. Your Honor, those are all my comments on this matter. Thank you, Your Honor.
Thank you, Mr. Hooper. Mr. Emerson, please.
Yes, I'll try and be as brief as I can, obviously bearing in mind that there was quite a lot in what Mr. Smith has just told the court that needs to be addressed. First of all, I should like to say that I think that his presence and his contribution to this discussion has immeasurably moved it forward in a number of respects, which I'm going to identify in just a moment. But certainly it's cast some significant light on the tactics that underlie the way the prosecution is handling its case. I want to deal first, as a matter of form, with the suggestion that I have been guilty for personalized ad hominem attacks. Mr. Smith and his team, and I'm sure Your Honor, will be aware of the distinction between an attack on the conduct and ethics of the prosecution and an attack on any individual. Mr. Smith happens to be the prosecutor and is therefore responsible for the conduct of the institution of the SPO. And so perhaps he feels it personally when the SPO is attacked, but it is well within the rights of the defense, and indeed well within the proper conduct of proceedings, to call out misconduct or strategies that are counterproductive to the administration of justice when they see them by an institution. There is nothing personalized about that, and I would make it absolutely clear to all concerned that in future, if there are, I hope there won't be, but if there are such occasions when the prosecution's conduct falls below the minimum standard, as it has here, then I will be my duty to bring that to the court's attention. There's nothing remotely inappropriate about that. Secondly, up until Mr. Black spoke, Mr. Smith spoke, I'm sorry, that's obviously a mental tick of mine, I apologize. Up until Mr. Smith spoke, my submission consistently has been the prosecution are trying to railroad the defense into a trial where they have the shortest possible time to effectively prepare. And I said, on the basis of that, that I inferred was unethical conduct, inconsistent with the repeated statements that the defense must have adequate time and facilities. There is, of course, an alternative explanation, which is that the prosecution has just lost sight of its core function, which is to ensure the fairness of the proceedings, that it has become too partisan and too committed to one side of the triangulation of interests that are at stake. That is the interests of the victims, the interests of the accused, and the interests of justice. That the prosecution simply has, not in bad faith, but out of enthusiasm for its project, lost sight of the basic functions of a criminal justice system that therefore may not go to their integrity, but to their professionalism. What Mr. Smith has just told us clarifies the matter beyond the slightest possible doubt. It is true what I said. He's just told us that I'm right, that the prosecution are indeed trying to create a situation where the defense doesn't really know the case it has to meet until the last possible moment, 3 months before the trial. He's told us that because he says it's justified by the need to protect victims and witnesses to leave the accused with the minimum possible time to prepare for trial. That is the policy. It is the policy. He's just told us that. So at least we don't need to be in any doubt anymore that the prosecution is deliberately trying to create a situation where it doesn't give us information we need to prepare the case at this stage, because it views it as being linked to the date of the trial, and they want to make sure whatever else happens that they don't give us that information until 3 months before the trial. So his intervention has very significantly taken us forward. We don't really need to argue whether that is evidence of unprofessionalism or a failure to properly recognize where the balance in the administration of justice lies, which is the most benign explanation, or ethical bad faith on the other. It seems less likely to be ethical bad faith now that Mr. Smith has stood up and owned it and told us that that is the prosecution policy. They do want to hamper the defense's ability to defend the case and to make sure that we have no more than 3 months before the trial to know what exactly the prosecution's case is. And that is not explicable by witness protection, because even after that date, there will be redactions. There will be anonymizations of witnesses giving evidence at the trial. So that the notion that giving us the defense case at an early stage, redacted suitably to protect witnesses, is going to somehow endanger witnesses is absolutely nonsense. There is no evidence, or at least none has been adduced in the provisional release applications of any witness in this case being intimidated by anybody. So that isn't true. I mean, if it was, one would imagine it would have been advanced by the prosecution in one of the 4 provisional release applications. Your Honour's decision on provisional release was based upon a general assessment of the overall collective risk that the accused might communicate with supporters. But so far, there is no, and you've denied them provisional release to prevent that happening. So far, there is no evidence whatsoever about to support Mr. Smith's dramatic suggestion that as we stand here today, there's witness intimidation going on. But even if there were, at some point, this trial has to be put on track. It has to be fair. And Mr. Smith's judgment of what is fair, namely keep the defense as much as possible in the dark till the last possible moment before trial, that's the imperative, which he told you just now is guiding the prosecution's policy in this case, and therefore explains all of their decisions that have, to me, appeared to be unethical and improper. It's deliberate, it's intentional, it's been decided within the prosecution as policy. So now at least we know precisely what is at stake here. You, Your Honour, hold the ring, not the prosecution. It's not for the prosecution to say what is in the interests of justice in terms of allowing a defence a fair trial. The notion that 3 months is enough time to properly investigate and prepare a defence case once you know exactly how it is put is, with my respectful submission, absolutely obviously wrong. And so in those circumstances, you hold the reins, not the prosecution. It is time to take from the prosecution their control over the way these proceedings are being handled. We now know openly and fairly that the prosecution is deliberately trying to delay as much as possible, the disclosure of any information, even in a redacted form, that might enable the defense to properly prepare for trial until 3 months before the trial. Well, we accept that the prosecution has decided that it must link the disclosure of the information that we asked for in the schedule to the date of the pre-trial brief. And now the submission very clearly is to Mr. Smith, thank you. We understand why you've been behaving in the way that you have up until now. We accept now, in the light of your explanation, that that does not show unethical conduct, merely an unprofessional lack of oversight and a blinkered approach to the prosecution's interests. But you do not hold the reins. It is necessary for the judge to make a balance. And in those circumstances, we will like you to provide the pre-trial brief and the missing particulars from the schedule on the 1st of April. At that stage, the defense can get on properly, prepare the case, and we can set a trial date. But it now, I mean, I do want to thank Mr. Smith for, as he said, mentioning the thing that hasn't been mentioned up till now. Not just that the prosecution's policy is driven by so-called concerns about witness protection, but at least it's now admitted formally on the record that is the prosecution's policy, to handicap the defense to the last possible moment. Now, obviously, we can have an argument about whether that's just and fair and where the line is to be drawn. But at least now we all understand that the prosecutor himself, that's why I asked for him to come and answer for it. The prosecutor himself has owned that policy. And we can see now, for all of the things that the prosecution have tried to do, that explains them all, because that's why they won't give the pre-trial brief until just before the trial. That's why when the trial date was suggested to be later than June, they wanted to move back the pre-trial brief date. That's why they won't fill in the details on the form. That's why the evidence is being disclosed in the manner in which it is. Of course, we had the note, the summary provided pre-confirmation, but that is not the same as what the prosecution proper case is, as it is put. In answer to Mr. Smith's complaint, that the defense is saying it's a case made out of tissue paper, why is it so difficult to investigate? That is exactly why it's so difficult to investigate, because if this were a case where an allegation was being made against Mr. Vasily that he committed this murder and that murder and tortured this person and that person, we would know what were the allegations we need to focus on and defend. Instead, we have a multiplicity of events over 34 different areas, all of which have to be investigated as primary facts, as if they were 34 different crime bases. And then we need to try to infer how the prosecution suggests that a man who wasn't present at any of them except one where he didn't do anything wrong is responsible for the acts of others. Now, if he doesn't understand why that's a more difficult case to defend than a straightforward allegation that somebody murdered somebody else, then I'm afraid he needs to perhaps reflect on his prosecutorial experiences, because it's self-evidently a more difficult case to investigate. And it's also self-evidently a case that needs a much clearer statement of the prosecution's case. So, in order to conclude...
Yeah, to conclude, please, Mr. Emerson.
I was just about to. In order to conclude, having heard the explanation of Mr. Black, it is not necessary... Mr. Smith, I'm so sorry. It's a mental tick. I'll get over it in due course. Having heard the explanation of Mr. Smith given in person, it is now unnecessary for the defense to pursue the argument that the prosecution's conduct is unethical. I leave that issue open, and I'm certainly prepared to pursue it if I see evidence of unethical conduct. But what we now have, as a result of me having raised my concerns on that, is an explanation from the prosecution that I was right all along, and that it is their objective to steamroll the defense into a trial that, in our submission, would be obviously unfair. And we now need to address the root cause of that problem, which is that the prosecutor himself has taken it upon himself to decide what fairness requires. And of course, that is a judicial decision, not a prosecutorial one.
Thank you, Mr. Emerson. I turn to Mr. Young, please.
Thank you. Your Honor, just two short points in relation to what Mr. Smith has said. First one, Your Honor may have noted that Mr. Smith has just stated quite extraordinarily that the defense in this case are seeking to delay this case. I say extraordinary for the simple reason that Your Honor knows, and we all know, the history of this case and how many years the prosecution had to investigate this case. So with respect, Your Honor knows very well the defense is simply seeking to have a fair trial. for the prosecutor to actually say we're seeking to delay the case when we've simply arrived into the proceedings only a matter of a few months ago is quite extraordinary. As far as the second point's concerned, Mr. Smith also made the point that Your Honour may have noted that defence counsel are well on their way to being prepared on this case. Now, with respect, Mr. Smith has no idea whatsoever of the state of the individual preparations of the defence teams. And I remind Your Honour and remind Mr. Smith that we've only recently been instructed, and some of us are beginning to assemble our offices, and we are at the very beginning of seeking to properly prepare this case. So for Mr. Smith to make the sweeping submission, which was utterly in ignorance of the position, that we're well on the way to preparing the case, is something that really should never have been said and is highly unfortunate. That's all I say.
Thank you, Mr. Young. Ms. Alejandra.
Your Honor, I join the submissions of the other defense teams. I have nothing more to add. They've said it all, Your Honor.
Thank you, Ms. Alejandra, and thank you for being brief. Mr. Prosecutor, do you want to reply to any of these submissions?
Nothing further, sir.
Thank you very much. We are now going to have a short break of 15 minutes. We'll be back in the courtroom around 1:10 The Hague time.
All rise. Mr. Emerson, if you can hear us, can you please turn on your camera? All rise. Please be seated.
Before we move to the next item in our agenda, which is the defense investigations, I would just like to ask one question to the SPO about a point that has been discussed before, but just to clarify one thing. On the issue of that was brought to the attention of the court by Mrs. Ménégon on the disclosure of witness testimonies when are shown to these witness testimonies some documents and the possibility of having a clearer, I don't know, links on legal workflow or possibility to identify these objects in a simpler way. Is there any technical possibility in legal workflow so that this could be made in a not too cumbersome way? You can take a minute if you want to discuss with amongst yourself.
Your Honour, I believe there is a manner of indicating it in legal workflow, and it would be our intention to do so. Some of the exhibits or documents that have been discussed during interviews have simply not been disclosed yet because they weren't part of the indictment supporting material and haven't so far been part of the Rule 102 1B disclosure. Noting the defence's interest in them, we're obviously happy to try and prioritise disclosure of such items in our ongoing disclosure process, and where possible without compromising protective measures, and at an appropriate point we will link such items. Thank you.
Thank you very much. Let me now move to the next item in our agenda, which is the defense investigations. And for this item, I'd like to turn to the defense first. I am mindful that the defense have started their investigation recently, but I would nevertheless be interested to know whether, based on the SPO's estimates, the defense can provide more information on the status of its investigations, whether the defense can provide information on any intention to make requests concerning unique investigative opportunities pursuant to Rule 99.1 of the rules, and whether the defense can provide information on any intention to give notice of an alibi or grounds excluding responsibility. Mr. Hooper, please.
Thank you, Honor. I can't help but feel that there's a profound fracture between the SPO and to some extent the court's expectations of what the defense can do or is doing and the reality. I can say that for all of us appearing before Your Honor, there is a degree of experience of conducting investigations and on behalf of defenses. First of all, I really want to spurn this suggestion that anything here is being structured in order to delay the trial. Again, I think that's a total misapprehension on the part of the SPO. I don't know why or where they come from to reach that view or to proclaim it. As I understand, it has been proclaimed to ambassadors and various people who aren't connected to this case. And that concerns me. let me say for my part, there's absolutely no suggestion of a seeking of delay. I can't even see what fruits delay would bring, to be honest. I don't know why the prosecution are flogging this to the extent that they are, under the banner of expedition and fulfilling that requirement. I don't know what seriously really underscores the prosecution's efforts here of repetition, as they've done and as they did in their submissions to you on the matter, the issue that we're not allowed and shouldn't discuss. Perhaps by persistence and repetition, they hope to influence Your Honour. That's my only conclusion. And I know Your Honour will resist that. Anyway, I put that aside, that particular issue that should not be spoken of. Investigations. The gulf between expectations and reality. I haven't started investigations. I repeat that, I haven't started investigations. If trial preparation was a 60-minute clock, I'm about 4 minutes into the case. I can't see investigations starting much before April. And I think I could say that even if there was not COVID, that might very well be the case, but COVID is a particular shackle to our efforts, as you know. It's not just a question of accessing the material presented in the way that it has been to create difficulties. I say to create difficulties, that's been presented in a way that creates difficulties for the defense. It's also just connecting with one's client, in my case, Mr. Hashim Thaci. He sits patiently waiting for me to come to The Hague, and I hope to do so perhaps later this month. May I say that in terms of connecting and discussing with a client, Zoom calls do not work. They're okay for a chat, and we have weekly and sometimes bi-weekly Zoom conferences. But it's certainly no manner of way to discuss the details of a case. And that, I suppose, is a COVID restriction. As I said in our submissions to you, Your Honour, we recently, at the beginning of this month, appointed someone to assist us in leading investigations. I've yet to meet that person. They're in Switzerland. So yes, there are difficulties, but don't think for a moment that that shows some level of indolence or incapacity or whatever on the part of the defence. It wouldn't be too surprising, it isn't at all in my experience at this stage, 3 months, I think, from disclosure, bulk disclosure in December, 2 months in, for the defence not, in fact, to be engaging in investigations. I misspoke at the last status conference. I had to go to the transcript to check if the prosecution was right when they said that I'd said it would take 18 months before I could start investigating. That was clearly misspoke. It must have been apparent to everyone, given that we've argued a trial should start in 18 months, that there would have been investigations by then. But I can't see our investigations starting, and certainly not fruitfully starting, for a couple of months. As for the other matters, similarly, I don't think it's a question of providing determining unique investigative opportunities, or indeed the appropriateness of alibis, particularly where there's joint criminal enterprise. charged, as opposed to specific offences on specific days, until we've had a better overview of the evidence. And so our submissions earlier on are very, very closely linked to all that. But I don't want anyone to think that these delays should be viewed as unusual. They're not. They're certainly not a delaying tactic. And in my experience, they accord with normal practice or normal procedure, the normal addressing of a case. Thank you, Honor.
Thank you, Mr. Hooper. I see that Mr. Krasnicki is requesting the floor. Mr. Krasnicki, do you want to speak specifically now, or can it wait for the other counsel for this round so that we don't interrupt between the defense teams, or do you really want to take the floor now? I turn to the interpreters. I don't know if the interpreters have the feed live in English, in Albanian, in order to translate. Sorry, Mr. Krasnicki, now the microphone seems to just start to work, so if you can please repeat from the beginning so we can get the translation. Thank you very much.
Well, I have some reaction to what was said by Mr. Smith, by the prosecutor, while he was talking on behalf of the people in Kosovo. On behalf of the people in Kosovo, on behalf of the citizens in Kosovo, I think that the people that are best vested to talk about them, it's us, the representatives of the people of Kosovo. 45 years of my life have been dedicated to freedom, to justice, and for the liberation of my nation from robbery. In the elections of 1992, I was elected by the people of Kosovo as an MP in the parliament of Kosovo. And it was a time that we were not allowed to constitute the assembly by the Serbian occupier. So after the Liberation Army, I've been represented in all the assemblies of the Kosovo people, and I have also been the representative of my people up until 2014, and I would very wholeheartedly plea to the prosecutor that if he were to speak on behalf of anyone, or if he were to speak on behalf of the alleged crimes happening in Kosovo, it would be best for him to be the defender of the policies of crimes and genocide that were implanted by the Serbian regime against my people from 1986-87 of the 19th century. Therefore, I would plead to the prosecutor not to speak on behalf of my people, not to speak on behalf of my nation, not to speak on behalf of the sacrifices of my people, because the people that are best vested to do that, it's us, it's the representatives of the people, not those that condemn the Liberation Army of the people of Kosovo. In particular, the latest war of my people for liberation, for freedom, for equality, and for the rule of law. So we, my nation, we ourselves, we have been supported at the international level. We have liberated Kosovo, and Kosovo is nowadays an independent state, a free state, so a state that is free from the Serbian regime. So this is all I wanted to say, and this is all I have to share with you for the moment. Thank you very much for your attention.
Thank you very much, Mr. Krasnicki. Then I will move back to the previous item, and I'll give the floor to Mr. Emerson, please.
Thank you, Your Honor. As you know, we've had a defense investigation team on standby and in fact, engagement since the 1st of January. And in particular, you will be aware during the provisional release pleadings, we were able to respond very quickly to some of the allegations that were specifically put against Mr. Vasily and obtain witness statements at short notice. So the team is there. The problem, as Mr. Hooper has already indicated, is that we're not in a position to brief them as to what exactly they need to investigate. And that does get us into the point that Mr. Hooper made so eloquently, which is we just heard Mr. Krasniqi make a plea to Mr. Smith to stop invoking the people of Kosovo as though he were authorized to speak for them, and one understands why that might cause offense. But I would equally ask them, a prosecution, as Mr. Hooper has done, to stop making the spurious and unfounded suggestion that the defense are trying to spin these proceedings out for some unspecified motive of their own. At first, it was suggested that that was a device to try to get provisional release by emphasizing the length of time that the trial would take. Well, that's no longer an issue because all 4 accused have been remanded in custody. And having been remanded in custody, naturally, the imperative on the defense is to get this trial through as quickly as it can be got through fairly and giving them an opportunity to properly defend themselves. So the idea that with 4 accused in custody, the defense lawyers are trying for some reason to spin the case out indefinitely. It's as Mr. Hooper says, it's difficult to fathom what the prosecution even thinks the motive would be for that strategy. But again, I'm afraid it's consistent with the general approach that the prosecution has taken, which we now have heard from Mr. Black openly articulated, that the best way to handle these proceedings with a nod and a wink is to rush them through with the defense knowing as little as possible until the last minute. So our position is very clear. I've had to stand my investigation team down because we can't afford to pay their salaries while they're doing nothing. But the earliest date that we can currently predict being able to instruct them is once we've digested the material and understood what we hope we understand the prosecution might be going to suggest its cases. In other words, that double analysis process I discussed before. And Mr. Hooper said a couple of months. I would say the very earliest for me would be beginning or mid-April, which is much the same period of time. I'd set it as the beginning of April as a target. But I think, like all targets, that's a little bit optimistic, but I would try to be ready to start them in the first 2 weeks or by the middle of April. But like him, and this is certainly not for any tactical reason, we haven't started. We can't start. I know you introduced this item by saying the defense are at an early stage of their investigations. Well, if you include the investigations relating to provisional release, then yes, you could say we're at an early stage of our investigations, but there's been no investigation in relation to the substantive allegations, nor can there be until we know the case we have to meet. And because the prosecution insists on not telling us the case we have to meet in the detail that we require, we're having to do that for ourselves before we start the investigation process. I do want to say in that context, the remarks that Mr. Black made this morning have at least
Mr. Smith.
I'm sorry?
Mr. Smith.
Sorry. I'm sure you all know where the brain connection comes from, but it's Jack Black is a US actor, and I can't seem to overcome that brain connection. I will work on it. Mr. Smith this morning has at least lanced the boil to provide an explanation for the things that the defense were puzzling over. He has proved that the defense were right in their suspicions that there was some a guiding mind behind the very odd way they were conducting these proceedings. And despite previous denials, which have been on the record, that the object was to it hampered the defense preparation until the last minute, that now is official stated policy. So at least the prosecution are no longer gaslighting the defense and the court, and they've admitted the policy openly. That's a huge step forwards because it enables the court to grasp the nettle. We now know what is the principle guiding the prosecution's conduct. It's set out openly. And that is a very good way of lancing the boil because, as they always say, sunlight is the best disinfectant. Now we have it out in the open. It's very clear that judicial responsibility is to take the reins from the prosecution. It's not for them to decide what the requirements of a fair trial demand. It's for the tribunal to decide that. You'd expect the prosecution to lean a little bit in favor of their assessment. Unfortunately, they've usurped your function altogether by telling you that the resources require them as a matter of primary function and core obligations and witness protection to make the trial as unfair as possible. So our defense investigation will probably begin around mid-April, and that coincides rather comfortably with the date I've suggested that you must or should order the prosecution to file its pretrial brief and fill in the schedule so that our investigators can start, as they did in my previous Kosovo trials at the ICTY, from the pretrial brief. And they can work to that and see what needs to be investigated. I've met with my international supervisor, but I can't get to Kosovo under these current conditions because of COVID. And of course, it would be ludicrous not to take the COVID situation into account until the vaccine distribution in Kosovo and in the United Kingdom has reached a tipping point and the disease is in recession. I'm not allowed to travel to Kosovo, and I therefore cannot meet my investigators in Kosovo. We can't, and there's no point in going there anyway, because we don't have the prosecution's pretrial brief. So all in all, investigations start mid-April, prosecution pretrial brief, please, at the beginning of April, and then we can get a sensible trial on the tracks. It's not up to the prosecution to decide what's a fair process. They've been usurping your function, and it's time to put a stop to it. Those are my submissions.
Thank you, Mr. Emerson. Mr. Young, please.
Thank you. I associate myself completely with the submissions of Mr. Hooper and Mr. Emerson. In our respectful submission, it's way too premature to entertain this or to be able to speak cogently about it. Your Honour, the situation will depend upon resources, funding, and of course, primarily, assuming funding and resources are available, upon our ability to read, understand, review, and analyse the prosecution case. And we're many months from doing that. And normally an investigation wouldn't commence until the defence have had adequate opportunity to consider the prosecuting evidence, analyse it, in order to make proper professional judgments over what needs investigating. So with great respect, it's we would say it's way too premature to engage in a constructive discussion on this. Thank you.
Thank you, Mr. Young. Ms. Alajandra, please.
Your Honour, we join the submissions of Learned Counsel. And additionally, the delay in receiving the translations in our case is greater because Mr. Krasniqi does not speak or read English. And this has affected the start of investigations for our defense team. He will only be able to give us full instructions once he has received the Albanian translations and reviewed them, Your Honour. Until then, we will not be able to start investigations fully. And if I may add, Your Honour, at this stage, we also cannot give any substantive update on the investigative opportunities or alibi for these reasons.
Thank you very much, Ms. Alejandra. May I ask the registry, Mr. Roche, if you could just recall to all the consuls of their availability to travel during the pandemic, and especially to Kosovo, because I know that there are restrictions in some countries whether to travel in the Netherlands or to Kosovo, but are you in a position to recall everyone what are the agreements that have been reached by this institution so that the consuls can travel? Mr. Roche.
Thank you, Your Honour. As we have previously been in discussion with some of the Council directly regarding this issue, as holders of diplomatic identification from the Ministry of Foreign Affairs of the Netherlands, and also with privileges and immunities relevant to their roles in relation to travel to Kosovo, they are exempt from any travel bans. As we can, of course, provide more detailed information and some contact details to Council to allow them to progress this matter. Thank you.
Thank you very much, Mr. Roche. I turn to the prosecution. Do you have any submissions on the defense submissions? Thank you.
Thank you, Your Honour. I will be brief. The law and the rules set clear requirements in relation to disclosure, onerous obligations, and we are complying with them. What has been discussed otherwise in relation to disclosure are additional things that the defence is seeking above and beyond what we are required to do. Material presented to the defence in disclosure has been presented in precisely the manner it was presented to the Chamber. The SPO policy is to have a disclosure timeline consistent with recognised standards for complex international cases, and that is what we are putting forward. In contrast to the significant work which the SPO has outlined here and in prior status conferences, and as is apparent from our ongoing disclosure, it is somewhat stark for the defence teams to indicate that despite the material they have been provided with, no investigations at all have commenced. Far from usurping functions of the Chamber, what the SPO is doing is providing grounded and informed submissions to facilitate the Chamber's assessment. With regard to the timing of the pretrial brief, which Mr. Emerson indicated was the starting point for investigations in cases he was involved with at the IC2Y, I refer him to paragraph 15 of our written submissions presented in advance of this status conference. On the question of timing of the pretrial brief in this case, the date which the SPO has indicated is the earliest possible date on which it could be provided, working rigorously. Reference was also made to COVID, and by no means would I understate that it's a significant challenge for all of us, far beyond the context of these proceedings. However, progress can and must still continue. There are ways of continuing to work, which the registry has helpfully just outlined, and the SPO has itself had to significantly adapt. The SPO has filed indictments, conducted multiple search and arrest operations, and continued to regularly conduct interviews. There are ways of working, and we encourage the defence to explore them. Thank you.
Thank you very much. Does any defense team want to take the floor? Mr. Hooper, please. Mr. Hooper, your microphone is mute.
Mute. Sorry
Thank
about
you.
that again. It may be trite for me to observe it, but the two matters I'm going to observe maybe seem a bit trite. But first of all, I don't know if there's anyone on the SBO benches who's ever conducted an ICL defence case. And perhaps if that is correct, because I don't think they have, then perhaps that might explain some of their misapprehensions about not only the defence role, but how we can and do go about it. I suppose in a normal situation, but by this stage of a case, I'd at least have visited Kosovo, if only to familiarise myself with aspects of the geography. I think that's always an important aspect at the beginning of a case. I haven't done that for obvious reasons. I'm sure the MFA, the document that the registry just referred to, is a very useful document. And I believe mine's winging its way to London as I sit here. But again, I'll say tritely, it doesn't actually protect us against COVID, which is the worry. Particularly as I read in today's English Times, that they've now uncovered a new mutation that has the disagreeable conjoinder of both the English mutation and the South African mutation. So I don't think COVID is done yet. But anyway, yeah, I'm very happy to have received my jab a week or two ago. That gives me a bit more confidence in order to engage in investigations and participate in them. And that will be done, I hope, as soon as I'm in an appropriate position to do so. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
I'm sorry, I just wanted to echo that last point. Diplomatic passage is not the issue. I don't really relish having to say this, but you know from previous correspondence that I'm not able to travel during the COVID pandemic for health reasons. And I'm one of a number of people who are no doubt in that position. And frankly, whilst it is out of control in Kosovo as it is, and will no doubt be even worse in the coming months, because there's just been a general election in which many people have come into contact with one another in very close quarters. Inevitably, the process of getting into Kosovo and talking to your investigators on the ground is extremely difficult. It's silly to talk about the fact that there are ways to work around it. Of course there are. We all know that. We're all now used to using video conferences for certain things. But what we can't do is get into Kosovo and prepare our defense with our teams. But in any event, all of this discussion is academic until we know exactly what it is we're having to investigate. No responsible defense counsel would set an investigator off with a set of papers and say, here, read these and do whatever you want by way of investigation. That's not how it works. We have to first analyze the evidence, which is only realistically been begun after Christmas in detail, because of course at the same time we've been dealing with provisional release pleadings and jurisdiction and indictment challenges, which are being filed in March, all of which has been hugely resource intensive. But at the same time, that the process of digesting the evidence is taking an inordinate length of time, because the prosecution has a policy, we now know, of giving us as little information as possible until as shortly as possible before the trial. So I make no apology for not starting a defense investigation. I'm not going to waste money and resources and time until I know what the case is I have to meet. So I repeat my plea that this again is linked to you ordering the prosecution to serve its pre-trial brief on the 1st of April. It's not true to say the date suggested is the earliest date possible. The prosecution no doubt has a draft in existence already. They may not think it's perfect, but they can redact it or amend it later on. They offered originally to provide it in June, bring it forward by a couple of months, and the trial will get on foot, on train, and we can get to a realistic early trial date. If this carries on, we're going to be having this same conversation in 9 months' time, where we'll all still be saying it's premature to fix a trial date. You need to take, if I may respectfully say so, grip of the situation, get the pre-trial brief out at the beginning of April, and then we can all get on to doing a proper job and a professional job. Because I think all of us, defense and prosecution, and no doubt the judiciary, want to see this trial regarded publicly as a really fair process. No one's going to believe the results if it isn't exceedingly fair. But when the prosecution has set sail with a policy that they now admit is designed to make this unfair, or at least to limit the ability of the defense to prepare their case, it's obviously time for Your Honour's hand to be on the tiller and to re-steer the course of the proceedings, get them on track, and let's all do a good professional job and just show the international community that this court is worthy of its mandate.
Thank you, Mr. Emerson. I don't see any other defense team asking for the floor. Then we will move to the last item on the agenda, which is the points of agreements on matters of law and fact. The SPO indicated being in an advanced stage in preparing an agreed facts proposal to the defense. Can you confirm that this is the case, and when will you be in a position to do so, Madam Prosecutor?
Thank you, Your Honour. I'll just respond very briefly to what was said on the previous item before moving to this one. Counsel for Mr. Thaci doubted whether members of the SPO have conducted an ICL defence case. I can assure him that multiple members of the office have, including amongst those present in court today. And I refer the Vasily defence again to review the timing of the pre-trial brief in the Haradinaj case. Turning to the agreed facts, we are indeed at an advanced stage internally in preparing a proposal, and we would envisage being able to provide that to the defence teams for their consideration shortly. Thank you.
Thank you, Madam Prosecutor.
Can I just respond on one point of fact?
Mr. Emerson, very briefly, please.
Yes, very, very briefly. One point of fact that keeps being made about the pre-trial brief in the Haradinaj proceedings. The point that prosecution doesn't seem to have understood is that the indictment in the Haradinaj and all other ICTY proceedings was a narrative indictment. In other words, it resembles a pre-trial brief. It enables you to go about understanding what it is you're alleged to have done and why, which incidents are supposed to have happened where and when, and precisely how it is said they link together. That is not the practice of the prosecution in this proceeding. Therefore, a pre-trial brief is essential. And that's why in these proceedings, we need to have that information before the investigators begin. It's a different situation if the indictment was a full narrative indictment. But that, I regret to say, is not the practice of these tribunals. So whichever way you look at it, we are hampered without that pre-trial brief, which is the next opportunity.
Thank you.
So that's the answer to that point.
Mr. Hooper, do you have anything to say to what the prosecution said about the agreed facts? No? Mr. Emerson?
Yes, so I'm grateful for whatever they provide for us as soon as they can provide it. We will not be able to respond, obviously, until we've done our investigation.
Thank you, Mr. Emerson. Mr. Young?
Nothing to say, Your Honour. We look forward to receiving them. Thank you.
Thank you, Mr. Young. Ms. Alejandra?
We will respond appropriately once we've seen the proposal, Your Honour.
Thank you, Ms. Alejandra. I would now like to ask the parties about their views on a suitable date for the next status conference. Madam Prosecutor.
I would just like to make clear on the record that the prosecution indictment is a narrative indictment. I don't have it directly in front of me, but it extends to approximately 50 pages. And in addition to the indictment, the defence teams have received the Rule 86 3B outline, which is not a document that is provided at any other institution. On the timing of the next status conference, we encourage and invite continuing active oversight of the pre-trial process and would welcome a status conference in early March. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Is this on general matters? Sorry, I've lost the...
No, this is just on the date for the next status conference.
Oh, yes. All right. Well, these also are time consuming, both in preparation and, as we can see, in the event. And I'm just wondering whether we need them every 4 weeks, perhaps every 6 weeks. I don't, in saying that, want it suggested that I'm delaying the trial. Thank you.
Thank you, Mr. Hooper. Mr. Emerson?
I understand both points of view. However, I think that at the moment there is a genuine need for muscularity of judicial intervention to ensure that these proceedings are put back on track. And so I would respectfully agree with the prosecution that early to mid-March. I don't know when Your Honour is going to rule on the date that the prosecution must file its pre-trial brief, or whether that ruling will be before the next status conference. But either way, while the prosecution is continuing to veer off course and try and take the tribunal with it, obviously we need to ensure very frequent judicial intervention so that these issues can be publicly ventilated and so that those who are observing the proceedings can see that the prosecution is not driving the judicial process, but rather the other way around. So yes, mid-March, please.
Thank you, Mr. Emerson. Mr. Young?
No, I agree. Mid-March would be appropriate.
Thank you, Mr. Young. Ms. Alejandra?
We are available at the court's convenience, Your Honor.
Thank you, Ms. Alejandra. The next status conference will be scheduled in due course, and you will, of course, receive an agenda before as usual. I invite the parties to make written submissions if they would like to raise any specific issue during the next status conference. At this point, I would like to ask the parties whether they have any other issues they would like to raise. And I remind the parties to give prior notice should any submission require the disclosure of confidential information. In that regard, I take note of Mr. Hooper's submission that the issue of getting case material to the accused is being resolved. And I thank the registry for that. And I hope it is going to be fully resolved very soon. Mr. or Madam Prosecutor, any other matter you'd like to raise?
No, thank you, Your Honor. Nothing further from the prosecution.
Thank you. Mr. Hooper.
Yes, can I start on a very positive note about the KSC and give my thanks to the registry that's been consistently and positively very helpful whenever we've requested any or made any demand of it. I include the Defence Office in respect of that too. But turning to the registry, we raised with the Defence Counsel, raised with the registry the difficulties of access of material, as John has just referred. And I understand that the registry is putting in place a computer link between, in my case, Mr. Thaci and the Defence Office that has been provided to us in The Hague. I don't think it will extend further than that at the moment. And as I understand it, it's obviously just limited to documents, but it means that documents can be put onto the computer and shared in real time with the client, which is it's been in place, that system at the ICC, I know, but it's being adopted or something similar. And I very much welcome that. And I thank the registry for their prompt response to our request. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
I'd like, if I may, to echo the comments of Mr. Hooper, not just in relation to the registry and the Defence Office, but also in relation to the Document Management Service. Our relationship with the court's administration has been exemplary, and so the comments that I have made in relation to the mishandling of this case by the prosecution do not in any way extend to the management of the court staff. If problems arise, as I suspect they will, in public about the perception of these proceedings, they'll be laid solely at the door of the prosecution and not at the door of the administration, who have done everything they can to ensure that the defence are as equipped as they can be, but obviously are hampered by the attitude that's being taken by the prosecution. The second point I wanted to make is a question, actually. You indicated that prior to the next status conference, you would like to receive submissions on any item to be included in the agenda. I'd just like to have some clarification, if I may. The submission has been firmly put on the record today, requesting you to make an order about the pre-trial brief being served on the 1st of April. You've heard submissions of both parties on that. My view is that the split pleadings have been dealt with and that the matter is ready for decision. But if you take a different view, then perhaps you would indicate that so that we can ensure that it is put on the agenda for the next status conference. I would much prefer that the matter is decided now so that we can all have an effective status conference in a month's time instead of continuing in the current vein.
Thank you, Mr. Emerson. That's absolutely correct. What I was referring to is if you wish to raise any new topic for the next status conference that hasn't been discussed today or in the previous status conference, please do so in writing. I wasn't referring to what has been discussed, I think, in a lengthy way and detailed way, which is a very good thing today. Mr. Young, please.
Nothing to add. Thank you, Your Honor.
Ms. Alejandra, please.
I have nothing to add, Your Honor, except my gratitude to the Defense Office and Registry for being so helpful.
Thank you, Ms. Alejandra, and thank you for conveying this to the registry. I'm sure it's fully deserved. Before we conclude today's hearing, I would like to organize matters in relation to the next review of detention by issuing the following oral order. The respective defense teams shall provide submissions on whether reasons for continued detention still exist by Friday, 26 February. Responses and replies to these submissions shall follow the timeline set out in Rule 76 of the rules. Finally, I would like to thank the defense teams for submitting their video link request 24 hours in advance of the scheduled hearing. In the future, however, notifications with respect to use of video link will not need to be filed before me. Correspondence with the registry, which includes an annexed consent form, will be sufficient. This concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters for their flexibility with the timing, stenographers, same, audiovisual technicians, security personnel for their assistance. This hearing is adjourned. Thank you.
All rise.